This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
Hello, everyone. This is Tom Fox. I'd like to welcome you to the FCPA Compliance Report on the Compliance Podcast Network. Today I have with me Michael DeBernardis. He is a counsel at Hughes Hubbard, and along with his colleague Jonathan Ziegelbaum, they recently authored a paper entitled Revisiting the China Initiative with a focus on FCPA prosecutions of Chinese companies produce results. I had the opportunity to visit with Michael on the China Initiative, and we talked about some of the developments around this, why it's significant, what developments have been seen over the past 6 months since the initiative was announced. Does the initiative tie into greater transparency for Chinese-owned companies in the United States? Does the China Initiative mean that the FCPA is being weaponized, and if so, what are the implications? What about Chinese pushback? Obviously, FedEx took some of the brunt from a pushback in another area, but if we think about GSK in China, what that might mean going forward, it's a fascinating exploration on the intersection of both foreign policy, trade sanctions, FCPA, and the Trump administration's apparent trade war with China. I know you will enjoy it. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Hello, everyone. This is Tom Fox back for another episode, and we are all in for a treat today because I have back with me Michael DeBernardis. He's fastly becoming a fan fave on the FCPA Compliance Report, and we're going to take up a topic today that frankly concerns me a little bit, and I'm going to explore this from Michael from really his white-collar defense perspective. So, Michael, first of all, for that incredibly long-winded introduction, welcome back, and thank you for taking the time to visit with me today.
Thanks, Tom. It's always fun to come on and chat with you about these interesting topics.
So what we're going to take up today, Michael, as you know, is the China Initiative. And I thought maybe you could introduce to our audience what the China Initiative is, most specifically around the Foreign Corrupt Practices Act.
Sure. So the China Initiative was announced by then Attorney General Jeff Sessions really shortly before he resigned. And its main focus was on putting resources in place, conducting training, and having prosecutorial emphasis, I'll say, around what the DOJ has termed Chinese economic espionage. So the focus was really on combating trade secrets theft, combating hacking by Chinese parties, but a really interesting component of the initiative, and it was laid out in a November 1, 2018 press release. There was a fact sheet that had 10 goals for the initiative, and sort of the one that's I think most relevant for our conversation today, and the one that maybe caught some people by surprise was a goal to identify FCPA cases involving Chinese companies that compete with American businesses. And so, the theory was this is just another way that the Chinese government and Chinese companies are acting unfairly towards U.S. economic interests. But this sort of particular goal of the China Initiative really stood out.
So the initiative around the FCPA, Michael, frankly concerned me if it could be interpreted as a weaponization of the Foreign Corrupt Practices Act, its enforcement and prosecution. I recognize that numerous commentators, or at least some, have alleged that in the past. I've tended to reject that because I didn't see any of that sitting where I do, is sort of watching it from the outside. But moreover, all of the companies that I had seen prosecuted or involved in enforcement actions had actually violated the FCPA, and that the facts on the ground certainly supported an enforcement action, and it supported the fines and penalties leveled against them. And my concern here is that now we other parties may be able to at least allege selective enforcement against the China initiative. What's sort of your thoughts on that?
I think that's certainly a concern, and it's one that I think a lot of practitioners in this area share. A lot of commentators certainly have shared the same. At the very least, it seems to be changing a new approach, a novel approach for the DOJ in these cases. I think if you talk to people who are inside the FCPA unit now or have been, the common refrain is that they follow the evidence, and the cases sort of evolve in that manner, and that particular industries and certainly particular countries are not targets. So this is certainly going to be a novel approach. I think the concern you've expressed is a real one, and it's one that in truth may ultimately hamper the DOJ in reaching the goal of the initiative. In right around the same time, actually, that the China initiative was announced, although it was just coincidence, that China passed a international criminal judicial assistance law to sort of formalize their process for assisting in foreign criminal investigations involving Chinese companies. And one of the stated formal reasons for denying a request for assistance is, that the crime appears to be motivated by politics, the investigation appears to be motivated by politics, or, there's another stated justification, which, China can deny assistance if the request seems to be based on, race or nationality. So by framing the initiative in this way, focusing specifically on Chinese companies, you're sort of providing fodder for Chinese authorities to deny requests for assistance. And really that assistance can be critical in trying to make one of these FCPA cases.
Michael, let me unpack that in a minute, because I want to go back to one of your opening remarks, which was the reason for the overall China initiative, not simply the FCPA component. And I think most Americans, if they don't recognize, perhaps acknowledge that China had engaged in unfair trade practices, and the efforts of the administration to curb that, I at least feel, are generally applauded within the U.S. business community. What I don't see is, or what concerns me is perhaps a disconnection of FCPA enforcement, which is not typically involved with counterfeiting, not typically involved with theft of trade secrets, not typically involved with cartel or other anti-trade foci, but obviously is bribery and corruption. Now, I recognize China does have what I call the Belton suspenders, but it's roads and bridges initiatives, and I'll get to that in a moment. But I just don't see a connection immediately between FCPA, anti-bribery, anti-corruption enforcement, and the greater goal for more fair trade between the United States and China. Is that a fair assessment for you to consider?
I think so. I mean, I agree. There are 10 goals of the China initiative. 9 of them really work together: combating trade theft, economic espionage, providing training to universities. In terms of combating economic espionage, you've got emphasis on combating and prosecuting violations of the Foreign Agents Registration Act. All of those things sort of work together, and this FCPA goal, it doesn't seem to fit within the broader scheme. So I do think that your thought is a fair one. That the effort of the U.S. government, which I think you're right. I mean, it's not just applauded by business community, but I think it has mostly bipartisan support of really curbing some of these unfair trade practices. Particular goal seems to be an outlier within that overall set.
So now let me turn to your concern raised about potential or lack of cooperation between China and U.S. prosecutors. I can remember when the GlaxoSmithKline case broke back in the summer of 2013. I was at a conference, and there was a former FCPA unit prosecutor who was on a panel, and I asked him if he could at least acknowledge that there were communications between DOJ prosecutors and their counterparts in China around this issue, without getting into the substance of any of those. And he related the following, that the Department of Justice and the Securities and Exchange Commission in the early part of this decade put on a series of workshops with their counterparts in other countries around anti-bribery, anti-corruption investigations and enforcement. And the reason was twofold. One was to actually teach these techniques, which were a little more advanced in the United States at that time, but it was also to develop relationships with other prosecutors. I think from the DOJ perspective, we see this most clearly with Brazilian prosecutors. But the answer the lawyer gave was that, yes, there were relationships developed, and that the global scourge of bribery and corruption is something that I think many prosecutors in many different countries feel very strongly about. And so that while the political disputes may be going on at the top, at least at one point in time, there were open communications between the kind of line prosecutors in various countries. And I guess after listening or kind of hearing your opening remarks on the prosecutorial aspect, it concerns me that we may lose those relationships, or the Department of Justice, I should say, would lose those relationships and their ability to have a conduit of information, even if it does not include specific prosecution of Chinese companies.
Another fair point, Tom. I mean, I think the efforts of U.S. prosecutors to create those relationships have been successful, very successful in certain places. Brazil is a great example, and less successful in others. And I think one of the places where really there hasn't been a ton of success has been in creating those relationships and really engaging in that cooperation with China. And it's sort of been a really poorly kept secret that the U.S.'s efforts to use MLAT's Mutual Legal Assistance Treaty, there's an agreement in place between the U.S. and China for this type of assistance, and that it has really been unsuccessful. And actually, again, sort of by coincidence, there was a recent case here in D.C. That shed some more specific light on this issue, and I don't want to get into the details of the case, which related to subpoenas that the DOJ had sent to some Chinese banks. But in the course of writing her opinion, Judge Howell in DDC brought up some real statistics on this issue, and I don't have them in front of me, but it was, I think the statistics that they had was there were 50 over the past decade. There have been 50 requests by the Department of Justice for bank records in China, and 35 of them have gone completely unanswered. The other 15 came back incomplete or with summaries rather than the actual evidence. And that there were, I believe there's 40 outstanding requests for assistance that haven't been even acknowledged or responded to by China. So the reality is right now, and part of the reason that the Department of Justice hasn't had success in bringing FCPA cases against Chinese companies is that they're not getting cooperation on the other side. And like I said, I don't think that announcing this initiative in this way necessarily helps that cause.
So now let me turn to Michael to two areas where I think FCPA, if not enforcement, certainly scrutiny would be appropriate. The first was, and we've had one example of this, what used to be called reverse mergers, where a Chinese company or investor would buy an existing U.S. company that was publicly listed. This was done more often in the early part of the decade, largely for investment purposes. But if you purchase a U.S. publicly traded company, you're going to subject yourself to a wide variety of laws, known or unknown to the Chinese purchaser. And there was a company called Rhino that got into trouble in that manner. The other area, though, is what I'd refer to as the Belton Roads initiative by China, where they were working quite diligently in emerging countries to build infrastructure projects, have massive infrastructure projects. And there's kind of either open secrets or undertoned rumblings or even complaints, maybe that's the better phrase, that the Chinese are not doing this on a level playing field, meaning that there may be gratuities being paid or other benefits being given to certain foreign government officials to facilitate these massive infrastructure projects. I find FCPA enforcement appropriate in those situations where the facts justify it. And certainly as to the second issue, I think it's well within the purview of the Department of Justice to try to protect U.S. companies through maintaining, or at least trying to maintain, a level playing field by penalizing bribery and corruption. Do you see any evidence of that in the China initiative?
Well, I think first I agree with you. I think those are two very reasonable places for an FCPA focus. The Belt and Road Initiative is sort of getting international attention for a great number of reasons. And there's actually been a lot of attention from the anti-corruption perspective. And China itself, to their credit, has held a number of workshops and initiatives to really try to make sure that the initiative is done with as much integrity as possible. They're providing training. Some of the development banks that are involved in various aspects of the Belt and Road Initiative have been chipping in to try to make sure that there is some level of integrity and an expectation that companies are not going to run wild and just start paying bribes all over the globe to win these lucrative contracts. So I'm on board. I agree with you that some FCPA scrutiny on those projects is appropriate. I think that the ultimate sort of issue there could end up being jurisdictional, whether the U.S. can find a way to gain jurisdiction over some of the conduct involved in that initiative, where the projects are overseas, and many of the companies that are bidding for those projects against the U.S. companies who might be involved may not have firm ties to the U.S. So I do agree with you. I think that that's fair. I don't know that it was the Belt and Road Initiative or even reverse mergers or even efforts recently in the Senate to change the accounting rules and disclosure rules for Chinese companies are formally related to the China initiative. I think it's a broader effect of this recognition that we really have to. China is a great economic power, and steps need to be taken at various levels to rein in what is viewed as unfair trade practices.
Michael, let me change the focus just a little bit to people who might be your clients or potential clients, U.S. companies, perhaps other companies, but certainly U.S. companies. And one of my fears is that an aggressive use of the FCPA per the China initiative could start up kind of either a tit for tat or even worse, Chinese authorities investigating U.S. or other Western companies. Now, we had one pretty good example of that, and I mentioned it earlier, GlaxoSmithKline back in 2014. Excuse me. And that prosecution was extraordinarily interesting, largely because it was based upon Chinese domestic law, which is quite severe around bribery and corruption and payment to Chinese government officials. And I tell people, wherever you want to be in life, under investigation, in trial, or in a Chinese jail is not any of the top three. And so if the Chinese begin to investigate U.S. companies, I fear that, but how do you think through, or how would you advise a U.S. company who's, literally done business for 20 years in China, a multinational company that's part of their routine business or potential growth opportunities they see in China? How do you advise them really at this point in June of 2019 with the myriad of things going on with this administration?
I'll tell you, it's an incredibly difficult conversation. I'm in a unique position because I have the privilege to work with a number of U.S. companies that do business in China, but I also have the privilege to work with a number of Chinese companies who do business in the U.S. and elsewhere. And there's pressure, this sort of unease on both sides of this. Even if we're doing our best, we may be prosecuted for, based on politics and based on this great trade war. Truthfully, the concern seems to be greater right now for Chinese companies that in response to the China initiative, in response to the Huawei, our Chinese clients are nervous and very uneasy by what they view on their side as politically motivated prosecution. U.S. companies that I've worked with in China are certainly wary, and they're taking steps to, make sure that if they haven't already, that make sure that the business they're operating in China is strictly complying with Chinese law, because the Huawei prosecution has been so public, and before that we had ZTE. There's a feeling, at least, that the U.S. has been more aggressive in sort of targeting companies as part of this trade war. At least that's how it's viewed on the Chinese side of this. But it's difficult. I mean, there's not a whole lot you can tell a company other than be careful, make sure that you're doing everything appropriately. That doesn't give a lot of comfort when companies are worried that the prosecution is going to be politically motivated.
And I guess even with that sage advice, we had the example this week of FedEx, who through apparently an error based in good faith on attempting to follow U.S. sanctions around specifically Huawei, ship packages that were addressed to Huawei to the United States. Turned out that was an incorrect decision by FedEx, but now there are myriad investigations going on in China. So I guess one of my other greater fears is that there are so many moving parts that even a company as sophisticated in shipping products as FedEx, as that's their business, can make in good faith a misstep, and that misstep could lead to much greater sanctions down the road.
I think that's absolutely possible and right. And the another thing you may start seeing, the U.S., just sticking with the FCPA context, has not been shy about prosecuting U.S. companies, European companies for their activities in China, and by doing so, to date, the Chinese government hasn't taken much of an action, a corresponding act with respect to that. If the U.S. prosecutes a U.S. company for corruption in China, there hasn't been much effort on the part of the Chinese government to also, prosecute that company. That may change, and you may have a situation where the DOJ is sort of teeing up cases for the Chinese government to take against U.S., American, and European companies.
Well, Michael, unfortunately, we're near the end of our time, but this has just been a fascinating discussion of not only a real-world problem, but one is literally changing by the day. So I look forward to continuing the conversation.
Yeah, thanks very much, Tom.
Hello, everyone. This is Tom Fox again. I hope you enjoyed this episode of the FCPA Compliance Report. If you have any questions on this episode, you can email me at tfox@tfoxlaw.com. Also, I'd urge you to check out Michael and Jonathan's most excellent article revisiting the China initiative with a focus on FCPA prosecutions of Chinese companies produced results. We, of course, link to it in the show notes. There's information on how to contact Michael should you wish to do so in that article. I hope you'll join us again next week where we have another topical conversation around the FCPA compliance and ethics. The FCPA Compliance Report is produced by the Compliance Podcast Network and is a proud member of C-Suite Radio. Thanks again for listening.